Afternoon, Advocate Maier-Frawley.
Good afternoon, Chief Justice.
Are you well?
I'm well.
Thank you.
Thank you.
I'm very well, thank you.
And I'm glad to hear.
Yes. You you became a prosecutor after completing your studies,
That's correct.
but that was only for about 2 years, it appears.
That's correct, Chief Justice.
And then you went to the nearest rates to serve articles.
That's correct.
Why did you stay on only for 1 year after becoming a qualified attorney?
Chief Justice, I was then doing matrimonial law, and in those early years of practice, the policy was to brief counsel in matters of that nature, and I was missing court. Court is where the law comes alive for me. And having come from a situation where I was in court nearly every day, bar for the time that I acted as control prosecutor, I really missed that aspect of practice.
Yes. And you joined the bar in 1990?
That's correct, Chief
And you've
Justice.
been a member for about 29 years, I think?
Yes, 29 years as a member.
Yes. And what about Silk?
Chief Justice, that was always an issue of timing. And although I applied for Silk this year, in hindsight and upon reflection, even then it wasn't the right timing. And if I could just explain my
Sure,
circumstances.
sure.
I started at the bar in 1990 and I worked for, as I've said in my application, for what I would call previously disadvantaged firms where you're dealing with real people with real problems. I carried on doing that for about 7 years before I could branch into civil law. In those early 7 years, I was doing crime, and I was also doing central divorce court work and maintenance court work, and, the odd matter that came my way in that context, also in the civil magistrates court. But there came a time when I really thought it would be good for me to try and do high court work, and I guess I was introduced into that sphere by means of junior briefs. Not that I was then briefed by the attorneys that were in those matters, but silks that I had come to work with were happy with my work and could refer me to attorneys that would or would not brief me. So sometimes, I would get briefs from it, and other times I wouldn't. But I started building up a practice and a reputation for myself. And then I got married in 1997. And by then my practice was already up and running, in a sense. And by the time I joined a different group in Sandown, when the bar kind of relocated from town, and I joined there in 2000, I was already considering the issue of starting a family. So I had pursued that. I had a miscarriage that was dealt with, and then I gave birth to twins in 2003. At that point in time, my hands were literally full. So for the next 3 years, my hands were full with 2 little babies making different and same demands at the same time. And I felt that that was important for me to be around. But at the end of that 3-year period, Chief Justice, I had to make a real choice, because I have been very, very driven by the fact of my responsibility to the children. And I can do no better, really, than to quote what one of the presidents of the United States said. I think he's the 36th president. Lyndon Johnson once said that the family is the cornerstone of society. And more than any other force, it shapes the aspirations, the hopes, the ambitions, and the values of a child. And if the family collapses, The children are the ones that are damaged. So I had taken time to have a family, and I needed to take time to invest in my children. So I was left at a crossroad choice. I was in a position where either I should leave the bar and become a full-time mother, because they had a lot of needs at that time, being young, or I should pursue my aspiration to fulfill my purpose in law and try and make a contribution to society. And there was also the economic factor that I'd been incurring expenses for 3 years, but I wasn't really bringing in an income. And to give you just a prime example, I think in those years I took on an opposed summary judgment brief. But on the morning of court, my daughter had woken up my baby with a high fever, and I'd had to take her for an emergency appointment. And my colleague had phoned me to say the judge had called the matter. And I said to him, I'm terribly sorry, my child has had a high fever, and I'm taking her home, and then I'm going to come to court. Please tell the judge that. And it was, I think, the late Justice Judge Bai, if I'm correct, in Gauteng. And he recalled the matter at 11, and I explained and put that on record, and he was incredibly understanding. But I realized these are difficulties that I'm going to have. And I was alert to the reality that the children would have to be my primary focus. So literally for the next, possibly after that 3-year period, for the next 6 or 7 years, they became my primary focus. My husband, my then husband, and I had discussed it. I could not carry on incurring expenses without paying for them. So although he managed the home front and the children's needs, I had to pay for my own personal expenses at Chambers. So what I did was I did work that I could manage to do if I got it. Attorneys, word had gone out, I'd had the twins and I wasn't accessible. But if I got work, I would take on the odd work, as long as it was short work, as long as it didn't take me away for days. And even if there were times that I would have been offered perhaps a more lucrative brief of, say, 5 days in Pretoria, and the children were sick, I couldn't afford to spend that time away when the children were sick. So I had to manage my situation and take on only that which I could do sufficiently to recover my expenses and pay my debts. So that was where my focus was. It was divided, and I did manage it conservatively in that way. When I got, the marriage had also started to experience some turbulence in that period, and I had to spend a lot of time focusing my endeavors on trying to save that marriage, particularly because I knew I'd been forewarned it's going to damage the children. I tried everything in my power, but it comes to a point where no matter how much you will, you can't change the will of someone else. And that resulted in a divorce in 2013, although the marriage had ended in 2012. At that period, I knew that I would have to return to full-time practice. So I did. But, you know, the less accessible you are to attorneys, they're not always understanding. So attorneys had by then moved on. And by the time I found myself in 2013 in a situation where I had to start from ground zero, 3 of attorneys that I'd known or had maintained, who had still given me the odd work in that 5-6 year period, they had died. 2 had left the country, 1 had left the province, and I was literally at a position where I found myself having to start all over, which I then embraced that challenge. And it started for me getting referral work from a particular colleague who was not in my group, who had also had twins and had understood very much the difficulties associated with raising them as a single parent particularly. So those kind of referrals allowed me then to get more continuous work in the delictual field, and that's just how seasonal practice works. Sometimes you're doing more labor work, sometimes you're doing even matrimonial work, sometimes you're doing some commercial matters, and other times you're doing delictual claims. So that is really where I found myself at that point. Until, of course, as I've disclosed in my application, I had some setbacks. So I had the violent spider incident, and then I had the other medical issues, whilst I also started to act on the bench. So in that kind of setting, my practice wasn't of the quality, I would say, or sufficiency, I would say, that would have really met the criteria for silk.
JP?
Thank you, Chief Justice. Avril, good afternoon. According to your spreadsheet that records your acting stints in Gauteng, you've done a total of 40 weeks, 40.
That's correct, JP.
And of those 40, I see you've done 11 of them in the opposed motion court,
Yes, JP.
5 in the third court, and 4 in the urgent court. These are all tough courts. How did you find doing that work in those courts?
JP, when I started, I suppose I found the volume overwhelming, in the sense that I started in opposed court doing something like 17 matters a week for many, many times that I acted there. But I think for me, it wasn't so much the challenge of the pressure, it was more, it became a challenge if you served a week in the urgent court, which is incredibly busy in Gauteng, both in Pretoria and Johannesburg where I sat. So that's very, very busy work. You may end up with more than one reserved judgment there. It's continuous and it's pressurizing and it's impactful work. But then if you go straight into a post-motion court after a week of urgent court, that's possibly where I found it more of a challenge because of the high volume of reading and judgments that I then had to get out by the end of the opposed week. But other than that, I enjoyed the special motions very, very much, and I believe I coped well in opposed and in urgent court.
Well, I'm sure you must have made the JP angry to put you from opposed to urgent, because that never happens.
Yes, it happened to me on one occasion, JP. That was very...
How long did it take you to write your opposed motion judgments,
JP,
on average?
On average, I think the longest time that I wrote any judgment was 1.5 months. But generally it was about 2 to 3 weeks or within a month.
Okay. And your third court or special motion judgments, how long did it take you to write them?
That was 1.5 months.
I see. Did you write all of them, your judgments, or did you give extemporaries?
I did give extemporaries in the opposed courts, in the urgent court.
Uh-huh.
And in fact, in one of the special motions when it dealt with postponements.
Yeah, but what criteria did you use, whether you could give an extempore or whether you should write the judgment?
Well, it was an extempore in the sense that if you're dealing with opposed arguments in the urgent court, dealing with urgency, also I prepare a lot of notes before I go in, JP. So I have the facts at my disposal, and once I hear the arguments, I write and I make notes. So I also familiarize myself with the relevant legal principles. Mainly those, what I call extempores in the opposed court, if they were given, or in the urgent court. There was, for example, one in Pretoria where I gave an extempore. I would stand them down till the Friday, and I would write them by hand and just gather my thoughts and put them into sequence, so that I could be more equipped to deliver those type of judgments.
Yes, but you agree with me that it's more expected of you to hand down extempores in the urgent court?
Yes.
Than in the other courts?
That's correct, JP.
I see. You've only done, is it 1 week in criminal work? Was that a week in appeals? Because I don't think you've ever done a criminal trial.
No, I haven't been put in trials, so
Yes.
I did criminal appeals.
But do you have any experience in criminal work?
I do, JP. I have experience from the years I prosecuted, and in the first several years of practice, I did
Yes.
criminal trials, and I also did the odd criminal matter thereafter.
I see. Thank you very much, Chief Justice.
Thank you, Judge President. MEC?
Thanks, Chief Justice. For all my crimes, I wouldn't have asked a question at this time, but there's a matter that worries me. I'm reading a letter here from advocates for transformation.
Yes.
And just when I go through what they are saying, I am particularly interested in paragraph 4 and 5, in which, in brief, they raise issues about your commitment to matters of transformation. If there was time, I would have taken you through what they say, but it's there. I just want you to help me understand these paragraphs.
Yes.
Of course, I do note that the Black Lawyers Association has not made similar observations, but I think our country is going through a very important process of transformation, and just for these points to be raised worries me.
Yes. Thank you, Commissioner. Commissioner, what I can say is what they've raised, as far as I recollect, is that I didn't bring in black juniors during the 29 years of practice. But I've explained my circumstances, that it wasn't a continuous or a full-time practice for a long time. However, I started assisting a black colleague as from 1990. That was when I was a junior. And I did that for a long period of 10 years, financially, and also referring briefs to him in the pre-apartheid and post-apartheid, or prior to the Constitution, even in those years. And that colleague went on to become eventually, in 2000, a judge of the High Court. I was always committed to address or consider and redress the inequalities of the past. So it's not like I had no commitment from the inception to transformation. I did assist financially for a long period of time. When I went and joined a group in Sandown in 2000, we had certain transformation group initiatives that we embarked on, one of which was that we started a group transformation fund. I think that fund commenced in 2002, so that was a fund for previously disadvantaged juniors that came into the group to try and support them financially. To particularly, the motivation was to create longevity for them so that they don't leave practice, because work is not always forthcoming. So that was a baseline to give them some sort of security of tenure. And that we contributed to, of 1,000 Rand a month for about 6 years. During my hiatus, when the children were born, from 2003 to 2006, I was really generating no income, so to speak. And I paid for my personal expenses precisely because I valued that contribution and I considered it important. When I returned to practice and full-time in 2013, around there, I myself had to start a practice right from ground zero. The work I was getting on a more consistent basis was in the personal injury sector, where I did work for PRASA. And on that, in those type of matters where I had a more built-up relationship with the attorneys that were briefing me, we did collaborate to give work to black female juniors and also black male juniors. And we particularly drew up lists. I would get referrals, I would give them names, I would promote the woman in my group, and they would then start briefing those women, which had two consequences. It reduced the work that I was getting, but it also helped me to participate and them in actualizing the policies and transformation. So the work that I did when I started rebuilding my practice wasn't work of the greatest magnitude or highest complexity. It was work that I could easily manage. It was work that was either in the urgent court, or it was opinion work, or it was chamber work. That didn't warrant the imposition of two counsel. I could never justify that to the client or to the attorney. My reason for doing the referrals, Commissioner, is because I had experiences during this period in 2015 where when I requested the client and the attorney, for me to bring in juniors, it would be met with a response, well, why can't you manage this on your own? If you need assistance, then obviously you can't, then maybe we must go and look for someone else. And then I would risk losing the brief. That was the attitude that I was facing. And also, in matters that I could not justify through complexity or magnitude, the invocation of two counsel, attorneys just didn't allow that for me. When I became aware of the bar rule that allowed you to make use of bar funds, I was then primarily acting on the bench. I had the surgeries and the long periods of recovery in between. So whatever work I did, which was more in the delictual claims, was work that I did like maybe one trial a month. And that's what kept me going in between, because I was away for long periods, Premier. So my practice did, unfortunately, take a knock. And that's really the truth and the reality that I faced. But what I did was I tried to do what I could. So I always made referrals. And if I was in the position where I was given a matter where I was already doing a trial, say in the one of the PRASA matters, I would then either approach, I would tell the attorney to please phone so-and-so in my group, and they would then approach them directly. I think also why I considered referrals to be an avenue of opportunity in where I found myself is because I had benefited from a referral. And that's how I could start maintaining a relationship, specifically in the period after 2013, with showcasing my ability. And that was the honest truth as to why I didn't bring in juniors.
Are you done, MEC? You know, I must confess that. Are you done, MEC?
Yes, Chief.
Thank you so much. I must confess, Advocate, when I looked at the documentation, I noticed that you joined the bar in 1990.
Correct, Chief Justice.
So I said you couldn't have joined the bar in 1990 and we did not see each other until I paged through. I said, "How? This is Avril. Weren't we on group 17 together?"
Absolutely, Chief Justice.
Yeah, it's just that you too far and now I'm wearing
Yes.
glasses. I couldn't recognize you.
And it's 30 years later.
It's
Chief
30
Justice.
years later, yes. Wow. Prof?
Thank you very much, Chief Justice. Good afternoon, Advocate Ford. I'm here.
Oh, thank you.
Okay.
Good afternoon, Commissioner.
Yes, afternoon, yes. You once baked a cake for a client.
Yes.
Yes. How would you describe that extension of empathy to the client? And also, how would that conduct be infused in the interpretation of the law?
I don't think I followed the very first sentence.
I'm saying you once baked a cake.
Yes, Commissioner.
So you once baked a cake,
Yes.
yes, for a client that was sick.
Yes, he was dying.
He was dying.
Yes, Commissioner.
Okay. So my question is, how would you describe that extension of empathy to that client, which you baked a cake? And the further question is, then how would that conduct as well be extended in the interpretation of the law?
In the interpretation of the law, I would say that that conduct possibly shows a spirit of Ubuntu, of interconnectedness, of just being empathetic to a person who you know is terminally ill, who's got now a month to live, and in fact did die within that period. It was when the matter was completed, and I had empathy and compassion for the person who was quite elderly and he had come through a very stressful time. And he knew his time was running out. So it was an act of kindness to show just that we don't just think of ourselves. We think of others and we do stuff for the greater good.
Thank you very much, Advocate. Then how would that conduct be transmitted to the interpretation of the law?
The conduct of baking a cake to the interpretation of the law, I'm not following.
No, you made mention of the Ubuntu principle.
Yes.
So when you infuse the Ubuntu principle in the interpretation, yes, how would that be extended? Particularly in relation to the promotion of the African philosophy.
Yes.
In giving content to our law.
Thank you, Commissioner. Well, it is infused in the sense that you would, for example, in interpreting, which is our duty, the common law, and interpreting legislation, it would infuse into a situation where, not because you're going or exceeding your powers in doing that, but where you would promote a fair and just result, and also in the manner in which you are conducting the process. So the interconnectedness and how your acts have consequences on others, in the sense of promoting access for justice, for example, by controlling the proceedings, which a judge would do, is to not allow legal occurrences to occur, whether they're procedural or substantial, that would take away or deny access to justice. And I think that's what I tried to demonstrate in the SABC judgment. Thank you.
Commissioner Kane?
I nearly, when you said you offered the cake, said as commissioners who could have done with the cake. But when I heard that the person was dying, I said, no.
Oh, yes.
Thank you, Chief Justice. I was singularly impressed by the description of the way you handled the Kretschmer matter and his response upon your finding against him, that you had conducted the matter in a way that he considered fair. Could you give us a description of how you went about that?
Just leave it on.
Thank you, Commissioner. Yes, it was an opposed, it was two combined applications. The one dealt with a contempt of court proceeding where it was alleged that the correctional services officials had breached the contents of earlier court orders, and there was more than one. And then the second separate application was where he was seeking further benefits within the correctional facility that he was housed. And he had also sought, I think, some amendments to the orders. So these were combined. But what had happened is that he had always appeared in the proceedings assisted by an attorney. So the attorney who had drafted all the papers would whisper to him and help him along the way, but he was the person who did the arguing. And he was passionate about his argument, but it was also difficult dealing with him because there were so many procedural issues that happened along the way. And there were in fact, three postponement applications that were brought. No, I beg your pardon, two. The first one was because the state had put up a supplementary affidavit of what...
May I interrupt you? We
Yes.
are pressed for time today. So if I could just ask you to describe what it was that caused him to thank you for conducting the trial in the way you did.
I think because I treated him as I would treat any other person. And that's really part of the oath of office, is that all people are entitled to be treated, are entitled to be protected by the law, and the law applies equally to all, but we treat all people fairly, and we treat them in a fair process. We hear them, we give them an opportunity to be heard, and we do it without fear, favor, or prejudice. So even the most lowly to the most highly gets treated the same way. And I think that's possibly what he was referring to.
Thank you, Chief Justice.
Thank you, SC. Commissioner Malema?
Thank you, CJ. Ma'am, female law practitioners during apartheid time, the white females, they too were somehow ill-treated and not considered like male counterparts.
Very much, Commissioner. There's always been this form of sexism towards white women, or any woman. Let me not say white, it's a gender thing. I've experienced it throughout my career, even when my career was prospering in the first 12 years of practice. I would face situations where a client would say, well, you're too young. I don't think you can handle the matter. Or they would say blatantly, I don't think you can handle the matter. They would tell the attorney, I don't think she can handle the matter because she's blonde. So those kind of indignities were, and the sexism was rife. And this, in fact, one thinks that there's gender parity today with the strides we've made in transformation. But it isn't. There are members of society that still believe that women belong in the home. And they would treat you as such.
Now, appointing you here, despite the fact that you are a white female, it will be a direct contribution towards the transformation of the judicial. Am I correct?
Yes, Commissioner, it would contribute to the gender representativity issue, the gender equality issue, and also the gender diversity issue.
Thank you, Honorable Malema. Honorable Dodovo? Thank you, sir. You're excused, ma'am.
Thank you, Chief Justice.
Thank you so much.
Commissioner.
Thank you. No. Oh, I apologize. I didn't see Commissioner Moima.
Thank you.
Thank you, Chief Justice. Good afternoon. I just want to get a sense as to whether, do you agree that there is a need for continuous engagement between the heads of the three arms of government?
I think there is room for that, Mr. Commissioner. The three arms of government must not only constrain themselves within their powers, but they must also be supportive of one another. So just as the legislature would initiate policies, the judiciary will possibly make orders that have an impact on those policies. So there's room for engagement. There's certainly room for engagement when it comes to promoting a legitimate, independent judiciary that is respected by the other arms of government.
Thank you, Chief Justice.
Thank you so much. As you go out, and on a lighter note, in Germany, colleagues interact, the leadership of the judiciary with the executive from time to time. In France, the head of the court tells me that even if there's a state function, he makes it a point to sit right at the back in the name of separation of powers, although he was a member of parliament before.
Yes, Chief Justice.
You're excused, ma'am.
Thank you very much. Thank you, Commissioners.